Um, Good morning, everyone. I can see that it's 11 o'clock and the participant numbers are going up rapidly now. So what I might do is just start an introduction to you all while some other attendees log in. So thank you for joining us for our weekly webinar. This week, myself, Lisa Dobie and Nicholas Yell are going to be talking about issues of consent and material contribution in the clinical context. Now, both of these are quite big subject matters, and so we'll do our best to go through them as well as we can for you. The slides will be available and circulated to you after today's webinar, and the webinar itself is being recorded and it will be added to our YouTube channel for you to watch later should you need to consult it again. A couple of housekeeping points. You'll see that there are some, there's a question and answers box that you can use if you have any questions. Please do ask any questions that you have. We'd be very happy to answer them. We're going to save some time at the end for us to deal with those questions. If there are any questions we don't get to, we will email you back with an answer, and equally if you think of a question afterwards or you're too shy to ask, or I don't know, we can just drop us an email after today. You'll see our emails at the end of the talk, and we'll be very happy to assist you with it. I would just say if you could please stick to the question and answers box rather than the chat or the raising the hands, because we'll be keeping an eye on the Q&A rather than all three of them, and it's easier than unmuting people as we go along. Okay, so the way that it's going to flow this morning, I'm going to deal with issues of consent, and then I'm going to hand over to Nick and he's going to deal with issues of material contribution. As I said, these are big subject matters, and really what we'd hoped to achieve this morning is to give people who are new to this area an introduction to these big topics, but also for those of you who are familiar with it to just refresh memories and give an update as to some of the cases in this area. These are subjects that it's always worth getting reminders upon. So without further ado, I'm going to deal with the issue of consent. I say in the hope that my screen will move. There it is. Lovely. So before I go on to deal with the kind of modern approach to consent, the post-Montgomery, it's worth looking at the development of consent in the clinical context, because it helps us understand it better. And when we better understand it, we better evidence it. And we better deal with it, whether we're acting for claimants or defendants. So prior to Montgomery, issues of consent, as we all know, were dealt with and decided according to the principles of the Bolam test. And this inevitably led to a paternalistic approach to consent, the kind of doctor knows best scenario. And the idea behind that, when you look at the ratio in some of the judgments pre-Montgomery, is that doctors didn't want to prevent patients or dissuade them from undergoing certain surgical procedures or doing what they felt was in the patient's best interests. So it was very much not about self-autonomy and about what the doctor thought was in the patient's best interests. But before we get to Montgomery, we do see a gradual shift and change in that approach, and we see that both clinically in clinical practice in the guidance that's being issued and the practice in that doctors were following, and also in the law. So a very quick look at Bolam. We know it very well. It's the test that we all know. A medical professional is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Putting it the other way around, a man is not negligent if he is acting in accordance with such a practice merely because there is a body of opinion who would take a contrary view. And that is also qualified in the Belitho test, that it has to be in accordance with a logical and responsible body of opinion. It's quite interesting to go back to Bolam, because a lot of people forget, or perhaps didn't realise at all, that there was actually a consent issue at play in Bolam. It concerned electroconvulsive therapy, and the substantive allegations were that a muscle relaxant should have been prescribed to prevent the pelvic fractures that occurred during convulsions, and that there ought to have been better manual control by the nursing staff to control those convulsions, but also, and interestingly, that there hadn't been, that the patient hadn't been given proper warning of the risks, and that was determined according to the Bolam approach that we all know. We then moved to a case of Sidaway and Board of Governors, again, that we know very well, no longer good law on this issue, but it illustrates very well the paternalistic approach that was being adopted at this time. And Lord Diplock says this: "No doubt if the patient in fact manifested this attitude by means of questioning, the doctor would tell him whatever it was the patient wanted to know. But we are concerned here with volunteering unsought information about risks of the proposed treatment, failing to achieve the results sought, or making the patient's physical or mental condition worse rather than better. The only effect the mention of risks can have on the patient's mind, if it has any at all, can be in the direction of deterring the patient from undergoing the treatment which, in the expert opinion of the doctor, it is in the patient's best interest to undergo. To decide what risks the existence of which a patient should be voluntarily warned and the terms in which such a warning, if any, should be given, having regard to the effect that the warning may have, is as much an exercise of professional skill and judgment as any other part of the doctor's comprehensive duty of care to the individual patient. And expert medical evidence on this matter should be treated in just the same way. The Bolam test should be applied." Very clear. It's quite interesting to go back to this case of 1985 and to have a read of Lord Scarman's very powerful dissent, because what this really did was lay the groundwork for the decision that we have in Montgomery and the principles that we follow now. He looked at the doctrine of informed consent that was developing in USA and Canada already in the 80s, and he says this: "It is, I suggest, a sound and reasonable proposition that the doctor should be required to exercise care in respecting the patient's right of decision. He must acknowledge that in very many cases, factors other than the purely medical will play a significant part in his patient's decision making. The doctor's concern is with health and the relief of pain. These are the medical objectives, but a patient may well have in mind circumstances, objectives and values which he may reasonably not make known to the doctor, but which may lead him to a different decision from that suggested by a purely medical opinion. The doctor's duty can be seen, therefore, to be one which requires him not only to advise as to medical treatment, but also to provide his patient with the information needed to enable the patient to consider and balance the medical advantages and risks, alongside other relevant matters, such as, for example, his family, business or social responsibilities, of which the doctor may be only partially, if at all, informed." And so you can see there that that powerful dissent by Lord Scarman becomes the, foreshadowed the decision in Montgomery that we follow now. And there was a further refining of the approach to consent at the turn of the century in the case of Pierce. And it says, "In a case where it is being alleged that a patient has been deprived of the opportunity to make a proper decision as to what course he or she should take in relation to treatment, it seems to me that the law, that if there is a significant risk which would affect the judgment of a reasonable patient, then in the normal course it is the responsibility of a doctor to inform the patient of that significant risk, if the information is needed so that the patient can determine for him or herself as to what course he or she should adopt." So you see some personal autonomy and self-autonomy kind of creeping in, but the test is very much still governed by the Bolam principles. We have a case of Chester and Afshar in 2004, which has some interesting dicta in it as well about the shift towards self-autonomy, but I'll come to Chester and Afshar later because it's a case that we focus upon in relation to causation and consent. And then we have the case of Montgomery, 2015, and as you'll know, for those of you practicing at that time, this is the case that prompted us all to go out and amend our pleadings to refine the pleadings in relation to consent. And it was a case that changed the approach and suggested that the Bolam test isn't the correct approach, that and tests that should be followed. But as we'll see later, when I go on to look at some of the subsequent cases following Montgomery, I think there was an assumption that it would result in a lot more consent cases succeeding, but we see still just how difficult consent is to be successful upon, and causation is still very difficult. And so in the case of Montgomery, it was a case involving the risks around shoulder dystocia in vaginal delivery, where the mother had gestational diabetes. That was recognised that it was a 9 to 10% risk of shoulder dystocia, and this wasn't warned. The patient wasn't warned about that. The claimant wasn't warned about it, and it was very much from the thinking of the case of Sidaway. If you look at the evidence in that case, where the doctor said that, well, if I warn about shoulder dystocia and offer C-section, then most patients will go for C-section, and we don't want to encourage that. We don't think it's in the maternal interest. And at first instance and at the first appeal in the Court of Appeal, the defendant was successful, and the claimant appealed to the Supreme Court. And what we have is the following decision. One development which is particularly significant in the present context is that patients are now widely regarded as persons holding rights rather than as passive recipients of the care of the medical profession. They are also widely treated as consumers exercising choices, a viewpoint which has underpinned some of the developments in the provision of healthcare services. An adult person of sound mind is entitled to decide which, if any, of the available forms of treatment to undergo, and her consent must be obtained before treatment interfering with her bodily integrity is undertaken. The doctor is therefore under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So you can see the mesh of the objective and subjective test. The doctor is, however, entitled to withhold from the patient information as to a risk if he reasonably considers that its disclosure would be seriously detrimental to the patient's health. The doctor is also excused from conferring with the patient in circumstances of necessity, as for example, where the patient requires treatment urgently, but is unconscious or otherwise unable to make a decision. Bear with me. There are also some wider issues that are really helpful and I think and worth a reread when you are dealing with a case of consent. They're dealt with on this slide here, and they're at paragraphs 89 to 81 of the judgment itself. And it says this: the significance of a given risk is likely to reflect a variety of factors besides its magnitude. For example, the nature of the risk, the effect which its occurrence would have upon the life of the patient, the importance to the patient of the benefits sought to be achieved, the alternatives available and the risks involved in those alternatives. The assessment is therefore fact sensitive and sensitive also to the characteristics of the patient. And I think when you read that, that will give you some really useful guidance as to what you should be focusing upon as a claimant and a defendant in your factual evidence when you're dealing with issues of consent. It goes on, the doctor's advisory role involves dialogue, the aim of which is to ensure that the patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives, so that she is then in a position to make an informed decision. The role will only be performed effectively if the information provided is comprehensible. The doctor's duty is not therefore fulfilled by bombarding the patient with technical information that she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. So gone are the days of just having a consent form and a tick box exercise and then a later explanation of what all of the terms meant within the consent form. It really is about the quality of the consenting process. And again, rereading these paragraphs are important because it helps us to focus our are factual evidence on the nature and the content of the conversation that was had about consent. And as we'll see in some cases where you have clinicians who've kept a really good note about the conversation surrounding consent, you have a really sterling defence. And then it goes on to talk about the limitations of the therapeutic exception, which, if I go back, was paragraph 88, where it's the doctor is, however, entitled to withhold from the patient information as to a risk if he reasonably considers that its disclosure would be seriously detrimental to the patient's health. That's not an easy get out for a clinician. And as we see here, it states, it is important that the therapeutic exception should not be abused. It is a limited exception to the general principle that the patient should make the decision whether to undergo a proposed course of treatment. It is not intended to subvert that principle by enabling the doctor to prevent the patient from making an informed choice, where she is liable to make a choice which the doctor considers to be contrary to her best interests. Thus, consent issues do not only go to the question of the risks of a recommended procedure, they also go to the question of what procedure is in fact recommended. There is now a clear obligation on medical professionals to discuss reasonable alternatives to the procedure the doctor would wish to recommend. So it's not simply a case of offering, let's take the example of surgery, because it's a clear example that we can use. Offering one form of surgery, there may be a range of alternatives that in those circumstances relating to that patient, alternatives should be offered. And we now know from the ratio of Montgomery that that is required. There's not only an emphasis on what the patient is told, but also how they are told about the risks. Many of us will have heard the doctors explain that they might list risks, but they do not dwell on them because of overemphasis on risks puts patients off beneficial treatment. And Montgomery places an emphasis back on a discussion around those risks rather than just ticking boxes. And the net effect of all of this is that the Bolam test isn't applied to the issue of consent, but as you can see from some of the wording that used within the ratio, there will be some instances where you will see you're still going to require some expert evidence on what is reasonable and in what circumstances, but it won't, because you look at what's rational, what the options are, and what the range of risks are, and you will be expecting your expert to comment upon that. And you can see Bolam creeping in, but it is not the cornerstone, it is not the test. What I've done is I've provided in the next two slides a list of successful cases since Montgomery and some of the unsuccessful cases since Montgomery. As I said earlier, I think when Montgomery was first handed down and there was a rush to amend pleadings, the view was that consent may be easier for claimants to get home on, and that hasn't proved to be the case. There are some instances where cases have been successful on consent that may not have been previously, but we still see a series of unsuccessful cases, a lot of them in relation to consent, and as I'm going to go on to discuss later, the arguments that have been put forward about causation on the issue of consent not always being successful. Ones to read, I mean, they're all worth a read if you're new to this area or you're refreshing your memory with this, but Webster's a good one to look at because it's a Court of Appeal decision in one of the successful Montgomery cases. And what Webster, that concerned whether a patient should have been offered earlier induction of labour, and the view of the clinician was that they were not required to offer earlier induction of labour, and they had expert evidence to support the fact that there was a competent and logical body of opinion that wouldn't have offered that. But post-Montgomery and the need for self-autonomy required the patient to at least be offered that, because it was a reasonable alternative and one that she would have wanted to have been made aware of, and she was able to establish on the facts that she would have opted for the earlier induction, and that would, in that case, would have avoided the consequences of a brain injury to the child. And so that case was successful, and it's one where it wouldn't have succeeded pre-Montgomery, so it's a good example. Spencer's worth a read. That deals with a PE of DVT case where the claimant had not been given the appropriate safety netting upon discharge of the symptoms to look out for. So it was a case of not being given the relevant advice upon discharge, and with the relevant advice they would have reattended and avoided the consequences of that DVT, because there would have been an opportunity to provide treatment that would have prevented the injury. I've provided a series of unsuccessful cases, and I'm going to look at some of these in a bit more detail. In particular, Shaw's an interesting one because it tried to argue that there was a standalone cause of action where a claimant had not been given the opportunity to decide upon their own treatment, and regardless of any test of causation or any loss that flowed therefrom, they say that they should have been entitled to damages just by reason of being deprived of the opportunity to decide for themselves, and that was roundly rejected. And we'll see a series of cases, Deuce and Diamond, all where they look to alter the test for causation, and I'll come on to that in just a moment. Brimstone's an interesting one because it looks at I said earlier that the case of Montgomery makes it clear that it's not just about providing the risks in relation to the particular treatment which is being advised, but it's also about looking at reasonable alternatives to that treatment. And it's how far does one go with that? Let's say we're dealing with an orthopedic surgery, and let's say it's some kind of replacement, knee replacement, hip replacement, shoulder replacement, and there's a whole range of different implants which could be used. What is the obligation on the surgeon to give reasonable alternatives to different kind of implants, and where does that end? Brimstone looks at this, albeit the claimant doesn't succeed on the facts of the case, so it doesn't offer a great deal of insight as to how far that will actually reach. But that was a case where the claimant alleged that the implant being used was experimental, and in fact it wasn't. It was new, but there was lots of literature about the success of the implant, and it was agreed that it was an implant that would be used by a wide range of surgeons and would do so competently and fairly. And so that case failed on its facts, but it's interesting to look at how far Montgomery might go in relation to the range of alternatives that need to be offered in order to satisfy the test. And A&E's Essex is an interesting one because that shows us that even with self-autonomy, the clinician does not have to warn of risks which are fanciful. Not just unlikely or 1 to 2% unlikely to arise, but actually fanciful. And in that case, there was no evidence to support. It was about chromosomal abnormalities, and the evidence suggested actually that there wasn't a chromosomal abnormality present, and therefore there was no duty to advise about the risks in relation to it. But that one's worth a read. I'm going to move on to the issues of consent because I'm aware of the time and that Nick's got to deal with material contribution, another meaty matter. But Chester and Afshar, those of you who practice in this area will have come across this case many, many times. Briefly, the background to the case. There was a 1 to 2% risk of a patient developing quadriquina syndrome following surgery. In this instance, the claimant had the surgery, the risk developed, she suffered the quadriquina syndrome, and she hadn't been warned about it in advance of the surgery or given an opportunity to consider whether she would proceed with the surgery. Now, it's a case where the risk materialising was not created by any negligence on the surgeon's part. The risk would have been present during any surgery that took place by any surgeon at any time. It was one of the inherent risks of spinal surgery. But the case of Chester succeeded, and it's led to a lot of cases since. And if you just bear with me, the judge had found the judge found that the surgeon hadn't been negligent, but that he'd failed to warn the claimant of the small risk that the operation could adversely affect her, and that she had been warned of the risk. She would not have undergone the surgery at the time that she did. Interestingly, the trial judge did not go on to find that the claimant would have always deferred the surgery or would have positively decided not to have the surgery, but simply that she wouldn't have had it on the day that it actually occurred, so it would have been deferred. In other words, she would have taken some time to think about it, and within the judgment you can see reference to the fact that it's not always black and white for patients. It's not a case of you've told me these risks and my decision is X and I'm firm about that. Very often they will ask more questions, they will do some research. We all have access to the internet these days. They might speak to another doctor, get a second opinion, consider their position, and that was the thrust of the evidence in Chester, that the claimant would have deferred the surgery to consider the position. And the answer to causation was answered in this way: I would accept that a solution to this problem, which is in Miss Chester's favour, cannot be based on conventional causation principles. The but-for test is easily satisfied, as the trial judge held that she would not have had the operation on the 21st of November 1994 if the warning had been given. But the risk of which she would have been warned was not created by the failure to warn. It was already there as an inevitable risk of the operative procedure itself. However skillfully and carefully it was carried out, the risk was not increased, nor were the chances of avoiding it lessened by what Mr. Afshar failed to say about it. I start with the proposition that the law which imposed the duty to warn on the doctor has at its heart the right of the patient to make an informed choice as to whether and if, so when and by whom to be operated on. Patients may have and are entitled to have different views about these matters. All sorts of factors may be at work here. The patient's hopes and fears and personal circumstances, the nature of the condition that has to be treated, and above all, the patient's own views about whether the risk is worth running for the benefits that may come of the operation if carried out. For some, the choice may be easy, simply to agree or to decline, but for many the choice will be a difficult one, requiring time to think. The duty is owed as much to the patient, who if warned would find the decision difficult, as to the patient who would find it simple and could give a clear answer immediately. The slides will be available for you, and you can go on to read these in your own time. It goes on to say, on policy grounds, therefore, I would hold that the test of causation is satisfied in this case. The injury was intimately involved with the duty to warn. The duty was owed by the doctor who performed the surgery that Miss Chester consented to. It was the product of the very risk that she should have been warned about when she gave her consent. So I would hold that it can be regarded as having been caused in the legal sense by the breach of that duty. So what we see in Chester is a modification of causation in certain consent cases, not in all consent cases, and Chester is very much a case on its own facts, and we'll see that from a series of subsequent cases that I've highlighted for you on another slide, that where the duty to warn is intimately connected with the risk that has materialised and they fail to warn, then you have this altered approach to causation. On this slide here, I've dealt with the first three cases. Sure, I've mentioned, which was the case which sought the standalone cause of action just because the patient had been deprived of the opportunity to decide, which failed for the claimant, which culminated in the case of Diamond, which I'm going to cover in a little bit more detail for you, but also the case of Pomfrey, which is, it's a first instance decision, it's a good judgment by His Honour Judge Cotter QC, which looks at the limitations and puts Chester into, confines it to the facts of its case, and illustrates how you can't just apply it to other contexts. So perhaps if I start there, Pomfrey. This was another case of spinal surgery. No allegation that the surgery had been performed negligently. There was an allegation with regard a dural tear had occurred, and again that can arise. It's a recognised complication of surgery that can arise with all due care and attention. There was an allegation about the bear with me, part A, a negligent failing to diagnose symptoms that were consistent with compression of the quadriquina. Yes, and then there was a finding that the neurosurgeon had delayed surgery by 10 days. So this was one of those instances where there was an allegation of delay, and so the surgery wouldn't have taken place on the day that it actually took place. And you will often see in clinical negligence cases where the claimant will say, oh, well, we've got a Chester and Afshar point then, because it wouldn't have occurred on the day that the surgery actually occurred. And because the risks are only 1 to 2%, then on the balance of probabilities, they wouldn't have occurred on that later date. So they take the modified Chester and Afshar causation test and apply it in contexts where consent is not a pleaded issue and is not the reason for the delay. And what Pomfrey does is say, well, actually, you don't modify the test for causation in those cases, because the modified test for causation is in the limited factual scenario that you're dealing with in Chester, where the failure to warn is intimately connected with the risk that later materialises. So it's one to be aware of, to show you the limitations of Chester, both if you're for a claimant and for a defendant. And His Honour Judge Cotter rejected the claimant's argument and said there's no basis to modify the usual causation test on the facts of Pomfrey. The facts in Chester and Afshar were very specific, and the failure to warn was intimately and closely connected with the risk that materialised, so as to justify the modification to causation. The facts in Pomfrey were that the same surgeon would have performed the surgery 10 days later, and the risks in presentation all would have been exactly the same as they were days earlier. Thus, the risk of dural tear occurring was exactly the same. Now, on that second bullet point, all of those risks were the same in Chester. They weren't altered by the delay, but the breach related to the failure to warn. And that was the difference. The key to Chester and Afshar is that there was a failure to warn, and that then caused the deferment of the surgery. Very quickly, Diamond and Royal Devon is this concerned a case about spinal surgery, but with an abdominal approach, where the claimant developed post-abdominal hernia that was then repaired with a mesh repair. And the complaint was that a year or two later, the claimant was considering having a further child, and she was advised against a further pregnancy where she had a mesh repair, and she then sought damages from Royal Devon and Exeter on the basis that the surgeon carrying out the mesh repair had not offered suturing as an alternative, but also that they hadn't warned about the future risks for pregnancy in relation to a mesh repair. And those were the allegations. The judge found that there was a breach on this issue. It should have been explained to the claimant that there was certain risk attached to a mesh repair should she become pregnant in the future. Of importance, the court concluded that the presence of the mesh did not prohibit future pregnancy, but it just created risks. And also that she should have been told about the primary suture repair, which was possible even if there was a high risk of failure, because in this case the factual evidence suggested that whilst the suturing should have been offered by the surgeon, it wouldn't have been recommended because it had such a high failure rate. And it's in light of that evidence that the judge found that on the facts of the case that properly counselled, the claimant would still have opted for the mesh repair. The judge considered the evidence on the issue and concluded, overall, in the face of this information, looking at the matter both objectively and subjectively, in the face of the advice which would have been given to her, it would have been irrational for her to opt for such a repair, and I find that she is not a person who would act irrationally. This was then appealed. Some of the elements, it's worth a read of this judgment in full. Some of the issues on appeal, the way that they were argued were slightly different to the way that they were argued at trial. So they say that the judge wrongly applied a test of rationality when considering causation and erred in concluding that it was irrational for the claimant to refuse the mesh repair. Wrongly rejected the claimant's claim for psychiatric injury because the claimant claimed that upon being told that there were risks to pregnancy, that she suffered shock, distress and consequential depression. And if the claim for psychiatric injury failed on conventional grounds, then the judge was wrong to conclude that the claimant's shock and distress were intimately connected to the failure to obtain properly informed consent, which was another way of putting the argument that we saw in Shaw, which was that there was some standalone cause of action just for the failure to give the patient the opportunity to decide for themselves. That had failed in Shaw, or had failed at first instance in this case, and it was slightly modified on appeal, but it was unsuccessful. The Court of Appeal reviewed the authorities of Montgomery and Chester and concluded Montgomery lends no support for the proposition that a failure to warn of risks without more gives rise to a freestanding claim in damages. So that has been put to bed. Chester has been analysed by the Court of Appeal in the same context. In the three cases I've got on the slide earlier. It was an unusual case on, this is Chester. Chester was an unusual case on its facts, but as noted, the crucial finding in Chester was that if warned of the risk, the claimant would have deferred the operation. So if you are running a Chester and Afshar point, you have to have dealt with these issues in the evidence, and if you are defending one, this is what you need to focus upon. The analysis of the Court of Appeal in Deuce was apposite. So if we look at some of what was said in Deuce, when paragraphs 86 to 87 of Lord Hope's judgment are considered in context, in my judgment it is clear that he's not setting out a freestanding test as the appellant contends, but rather the circumstance which justify the normal approach to causation being modified. That modification was to treat a but-for cause that was not an effective cause as a sufficient cause in law in the unusual circumstances of the case. This is also how the third member of the majority, Lord Walker, approached the matter. Bare but-for causation is powerfully reinforced by the fact that the misfortune which befell the claimant was the very misfortune which was the focus of the surgeon's duty to warn. So it's again re-emphasising the decision that we see in Pomfrey, which is you can't just use a Chester and Afshar point because surgery might have been undertaken on a different day relating to some other breach. It was the powerful reinforcement provided by the close link between the injuries suffered and the duty to warn that led Lord Walker also to conclude that but-for causation was sufficient. So where does this leave us from a practical perspective? Causation is not going anywhere. It's going to keep cropping up. It's an issue we rarely see stand alone in cases, but it's usually an add-on in the pleadings. But sometimes the substantive issues of breach fall away and we're just left with causation, and you can be facing a trial just on a causation point. I've had variable experiences of how it has been evidenced. There have been gaps sometimes in claimants' evidence in relation to the causation points. So if they've been given that advice, what would their decision have been? And sometimes that has been lacking in their witness evidence, for instance, and it's an oversight and to be aware of it. You need to consider to what extent your expert can assist you. So the test is not Bolam, the test is that set out in Montgomery, but you will see from the test in Montgomery as to, for instance, reasonable alternatives, you're going to be assisted by your expert on that. So have a dedicated section within your expert report dealing with these points. And factual witnesses need to deal very carefully with it. Go back to those paragraphs in Montgomery, paragraphs 89 to 91. I've set it out on a slide about the wider issues. Address each of those points. Look at the personal characteristics of your claimant. Deal with why it might have made a difference to them. Can there be a potential irrationality argument that we saw in the slide earlier? Why wouldn't it be irrational for this claimant in this scenario? Equally, the counter argument for the defendant. There needs to be good record keeping by your clinicians. One of the cases that was unsuccessful post-Montgomery, there was a consent form that had been completed incorrectly, and the risks were not set out as they should have been, but there was a very good conversation between the clinician and the patient that was recorded in the notes, which was sufficient and was adequate consent and proper informed consent, and that gave the defendant a defence. And so record keeping, it has to be more than handed a leaflet or completed the consent form in cases that are beyond the run of mill. And beware that Chester and Afshar points are taken and pleaded in cases where they are reliant upon the modified causation test, but they may not be permitted to rely upon that modified causation test, because you have to ask yourself, is this about the failure to warn of the risks, and is that what has deferred the procedure? So those would be my practical tips, and I've taken up more time than Nick would have allowed me, so I'm now going to move on to Nick's slides. Material contribution.
Well, good morning, everyone. My experience, and probably yours as well, is that it's sometimes easier to establish the breach of duty than it is to establish causation. As we all know, the general rule in clinical negligence cases is that the burden of proof is on the claimant to establish not only liability but also causation, and that's the House of Lords case of Wiltshire and Essex Health Authority. But I think that sometimes there is a degree of confusion about the causational aspects of a claim that we really need to look at. Causation can be divided into legal causation and factual causation. I'm not going to deal very much with legal causation. I think that, let's have the next slide, please. Obviously, there is the legal question of whether an injury or loss falls within the scope of a defendant's duty to the claimant. So, for example, there are cases where a particular head of damages, even if it has been caused, will not be recoverable as a matter of law, and likewise economic loss. I'll come back to a couple of points later on legal causation, but I think what will usually concern us the most is the issue of factual causation, whether a breach of duty has actually caused an injury and loss, and what is meant by that. Now, the classic but-for test, in a sense, but for the breach of duty would the damage have occurred, is not always determinative. It will be in some cases, but it's not always determinative of the causational issue. And that's why we have the next slide, Lisa, please. The issue, therefore, is one of material contribution. So if for some reason the but-for test is not appropriate or applicable, you then go on to the question of whether there is material contribution that can be proved. Now, if a claimant can prove breach of duty made by more than the breach of duty made more than a negligible contribution to the injury, the claim will succeed. And you'll see the three cases there that establish that. There's the old case of Bonington, Castings and Wardlow, and then Balian Ministry of Defence, and the Privy Council case of Williams and Bermuda Hospital Board. It is important to bear in mind that there is still the obligation to prove on the balance of probabilities that the breach of duty caused more than a negligent contribution to the injury, that it made a material contribution. So if it's only a possibility, I'm afraid that that is going to lead to the claim failing. So that's quite important to bear in mind. So simply by showing there is a possibility is not sufficient to satisfy the burden that exists. Now, the material contribution will apply to damage that's occurred. In some cases, it will be the risk of an injury developing. It applies to sequential and cumulative causes. You can envisage circumstances where an injury has been sustained and there have been a series of sequential causes to that injury. And it also occurs to where there is simply a single agency, and the issue in the case is whether that single agency has made a material contribution, and can that be proved on the balance of probabilities that that is the case. Now, it's important to bear in mind that the materiality may be a material increase in the risk that can be sufficient to establish the causal link. That's the old case of McGee and the National Coal Board. This may not help if there are multiple potential factors which may or may not have caused the injury. And that goes back to the Wiltshire and Essex Health Authority case, and the point that I was making earlier, that simply by this issue of material contribution doesn't get you round the fundamental problem that you still have the onus of proof, and the claim will fail if you are unable to prove that. Now, there are exceptions to this. There's the so-called Fairchild exception. That's a case, as you probably all know, of exposure to asbestos dust with multiple defendants. They were employers and ex-employers, and the claim succeeded because each employer's breach of duty had materially contributed to the risk of contracting the disease. And so that was the Fairchild, and it was followed in the, I can't even begin to pronounce the name of the case, but it's on the slide. And that's a case where there was simply one defendant rather than multiple defendants. And maybe the Fairchild exception can be seen as a sort of pragmatic response to a very real difficulty in practice, and a sort of general feeling that employees who've suffered very serious injury as a result of exposure to asbestos should be compensated. Could we have the next slide, please? Now, the Fairchild exception only applies if it's impossible to satisfy the but-for test. So the but-for test is probably a good place to start with, and the impossibility is due to the existence of another potential causative agent, tortious or non-tortious, operating in the same way. And that's the Barker and the Chorus UK limited case. As you probably all know, the House of Lords determined that damages are irrecoverable for the simple loss of the chance of a more favourable outcome. That was applied to clinical negligence claims. It's not the same rule that's applied in other areas of professional negligence law. It was a controversial decision, a 3-2 decision, and I think that one of the logics behind it was a fear that the National Health Service might be overwhelmed by claims if a claim simply for the loss of a chance was allowed. But that is the law. Can we move to the next slide, please? And therefore, one has to prove either that it caused or materially contributed, unless you can rely on the Fairchild exception. There are one or two points to note with regard to factual causation. In considering causation, the assumption is made that but for the defendant's breach, he would have properly discharged his professional duty to the claimant, even if factually he would not have done so. I mean, if the rule was not that, the defendant would be able to rely on their own incompetence and say, well, I would have made another mistake, and so it's the claim can be defended on that basis. Could we have the next slide, please? Now, turning now to how causation really kicks in relation to heads of damage that are claimed. Quite often, you will have a claimant who has sustained a physical injury as a result of the breach of duty, but a large part of the claim will be the psychiatric injury that that claimant has sustained. And quite often, it will be that the psychiatric injury on probing, well, there will be various causative factors, deaths in the family, alcohol abuse, etc., etc. And the question therefore arises as to how that issue is going to be dealt with. Now, the solution of the Court of Appeal in BAE Systems Operations Limited and CONSAC was that where harm had more than one cause, the defendant should pay only the proportion attributable to his wrongdoing unless the harm was truly indivisible. Can we have the next slide, please? Now, it's quite difficult to distinguish between cases in which harm is truly indivisible and apportionment therefore wrong. If it is not truly indivisible, the court is entitled to make a sensible attempt to apportion liability. Well, in practice, that means a very rough and ready, arbitrary, how one actually does it is very difficult. And so various euphemisms are used, like a broad brush approach. But an injury is to be regarded as single and indivisible, where there is simply no rational basis for an objective apportionment of causative responsibility for it. And that's Lord Justice Laws in the Rahman and Area Rose Limited case. You could say, if you take the example of somebody sustaining a psychiatric injury which has multiple causes, how possibly could you start to apportion between those causes? Could we have the next slide, please? The courts do it, despite the fact that it's extremely difficult. You can question how satisfactory such apportionment exercises are, but it frequently occurs in practice that they can say, well, half the symptoms are attributable to the accident and half are attributable to matrimonial problems or whatever. In carrying out that apportionment, the court has to take account of pre-existing conditions, and that really goes for physical and psychiatric injuries. And if at the end of the day the court decides that it's an indivisible injury and apportionment is not possible, then it's all or nothing. If a claimant proves a material contribution to the indivisible injury, damages are recoverable for the entirety of the injury sustained. If the claimant cannot, they are not recoverable. So the temptation has been really for the court to apportion, because with the indivisible injury, you're in a situation that the claimant is almost by definition either being overcompensated or undercompensated. And obviously that's slightly difficult to reconcile and square with the Gregg and Scott, that damages are irrecoverable for the loss of a chance. Could I just raise two other really short points? Uh, One point in relation to legal causation is frequently you can have an argument about whether the chain of causation has been broken by a novus actus interveniens. So, for example, one might have somebody injured in a road traffic accident, and then the medical negligence occurs after the road traffic accident, and the extent to which the medical negligence is a novus actus interveniens. In practice, it's extremely difficult to prove a novus actus interveniens to break the chain of causation, and but it's there as a factor that needs to be considered. The second thing is, of course, that where you have successive injuries caused, for example, by a road traffic accident and then medical negligence, one really has to look at what the causes of the two incidents are. So typically, the damages in the medical negligence case will be assessed in the context of somebody who had pre-existing injuries as a result of the road traffic accident. And what would happen in those circumstances is that the two tortfeasors, and obviously it can be more than two if in appropriate cases, the two tortfeasors will be able to argue between themselves as to whether there should be indemnity, whether there should be contribution. And so causation is really dealt with in that way. I think that really, it's been a sort of romp through causation. I think that's really all I'd want to say, unless anyone's got some questions.
We had one question in the question and answer section, which has been dealt with, but I don't think we have any others. So if anybody does have any questions, please ask them now and we can deal with them, or feel free to email myself or Nick afterwards. Our email addresses are there. Just to say, next week we have a further webinar on 24th of September that will be delivered by Sarah Prager and Andrew Spencer on the Athens Convention. So those travel lawyers out there will be interested. And at the 1st of October, they will be looking, Sarah Prager and Henk Soda will be looking at the Montreal Convention. So please do tune in if that applies to your practice. And thank you for listening. And if there are no questions, then we will say goodbye, but we'll stay online for a couple of minutes in case anybody wants to ask a question while other people are signing out. Otherwise, feel free to email us, and the materials will be circulated shortly. You'll get those, and recap anything on YouTube if you need to. Thank you. Bye.